A very good afternoon to you. We continue our special coverage of the court proceedings as they relate to Rigathi Gachagua's impeachment by the Senate. My name is Olive Burrows, and this afternoon I'm joined by Dr. Martin Olo, who is the head of Public Law, Daystar University. And we also have pictures coming to you live from the Milimani Law Courts, where we have Seth Olale and Purity Zuya on standby. And this afternoon, as per instructions given late yesterday evening, the court will be hearing arguments on the application for recusal of the judges, an application made by the legal counsel of Rigathi Gachagua. Daktari, under what circumstances ordinarily would judges recuse themselves from a case?
First of all, thank you for having me, and to start by saying that judges are human beings. They live in the world, and they at times have interests or at times have opinions. They could have expressed themselves on an issue, and those opinions or those interests may come into play in a matter that they are being asked to adjudicate upon. In that case, it is normal for judges themselves to recuse themselves, to say, look, on this matter, I seem to have a bit of familiarity and a bit of an interest, or I've published something about it, and I would not want to preside over it because I'm likely to be biased from where I sit. But then also, if one has a reason to believe that a certain judge in this case has an interest or has an opinion which could affect the objectivity in the matter, then they can raise it. So those are the areas that you can look at. And if they know something about the case, then you can raise it. So it is something that would normally happen in the course of duty. The question is, who do you raise it to, and who decides whether they have an interest or not? And that is our issue here. Mm-hmm. Yes.
So yesterday, the judges ruled that their constitution was done legally after yes. A preliminary objection raised by Rigathi Gachagua's legal counsel. Wouldn't that have settled the issue? Why do they now have to come back and hear the issue of recusal?
Okay. The first issue was the DCJ in order, or was it right for the DCJ to select or to empanel that bench? That was the first question. It's a legal question, and I think they said that according to them, they didn't see anything wrong, and that's why the deputy CJ is the deputy president of the Supreme Court and therefore deputizes the CJ. So that they settled it. That did not go into whether they were the right people or not. Now later is when this application came to say, wait a minute, but you guys, you sat, and one of the allegations is that you sat on a Saturday and made an order. We appeared before you, and you declined to make an order. You took it to 29th of October. We suspect you're biased. That's the first issue they've raised. The second issue they have raised is again with one judge whom they are saying they appear to be very close with the deputy president nominee. They have raised that one. The third one, they have said that one of the judges, their spouse, has been nominated into a board that is a government board. Therefore, they seem to have an interest to protect in government. Now, those issues are significant. The challenge I have is that if these issues are true, then the judges ought to down their tools. Now, you will ask, why at this stage, why are they treating this issue as important? Yes. The moment your legality or your very presence in presiding over matter is challenged, you must then sort out that issue first before you move on to something else. Otherwise, you'll be accused of ignoring what was raised and of being biased. Mm-hmm. So it's right for this to be raised now, to be dealt with. Of course, others have said, these guys are just wasting time, whatnot. No. Legal processes are legal processes. Let's give each party their day and their say. And what are people in a hurry to do anyway? Mm. We have no crisis. We still have a deputy president in place because there's conservatory orders. We still have a nominee in place because already they have been vetted. So we already know.
Is that a crisis in itself?
There's no crisis. We already know if you just turn this way, we go back to the status quo. We turn this way, we can actually swear in the other one. So there's no crisis.
There's no political crisis because we have a deputy president, impeached deputy president,
yes,
who has lost the confidence of the executive and the legislature, who he would be required to work work with and whose office has essentially been disabled. Then we have one who is in purgatory, as it were. He's pending. He has been approved by the National Assembly on nomination by the president, but he has not substantially assumed office. Does that not create a political crisis?
This country has once operated without a vice president. There was a time when Moi just let off Saitoti, and then he went again on the street and said, "You people, you think bringing back this guy will bring food on the table?" And then he brought him back. The point I'm making is that there is no crisis. And yes, we can live without a deputy president because there is a constitutional mechanism. If there's a crisis right now, the speaker is next in line. The constitution has various provisions to take care of any crisis. So we shouldn't be worried as to want to do things in a hurry and trample upon a judicial and fair trial and human rights issues.
Are you saying the office of the DP is not a critical office?
Yes, that's what I've said. That it's not a doctor. It's not a medical doctor who is the only surgeon in town that if somebody is in ICU, nothing can happen. As a matter of fact, if they are not there to perform their function, somebody else in the line can perform that function. So let us not try and imagine a crisis where there's none. Anybody who is trying to argue that we are in a crisis is in a political field, not necessarily a legal field. Because if you asked us now that the president is not there and the deputy is not, what is next? We'll tell you the speaker is next in line. So from a constitutional perspective, no crisis.
All right. So some of the arguments we had yesterday, because there were arguments that there's an attempt to delay the hearing of the matters that were filed as urgent, certified as urgent by the court. And that is 2 applications by the Attorney General, by the National Assembly, that the stay orders in place regarding Kithure Kindiki substantively, or rather being sworn in, need to be lifted. That's the application by the AG, by the National Assembly. And they're saying this should have been disposed of first.
Not at all, not at all. In fact, they are wrong because the moment you have a conservatory order, the court is saying, conserve what is, keep it as it is, as we hear whether or not there's a breach of the law. So that cannot be overridden by some other desire by some people to quickly swear in somebody. What is the hurry? What is the crisis for swearing in somebody who is already a cabinet? In fact, the problem is on the other side. Mm-hmm. The person they want to hurriedly swear has not resigned as a cabinet secretary. Therefore, constitutionally, shouldn't even be sworn in as a deputy president because he does not qualify to be sworn in. So there are issues on that side that if they rush, they will be making the very mistakes. Some of those very issues are being canvassed in court. The issue as to whether there was a properly constituted IEBC as to give the advice that is allegedly given is being canvassed in court. So there are more weighty issues to be dispensed with in terms of the nomination. Not Gachagua is in office. So politically, he's not in office. Legally, he's in office. So again, what is their crisis? The political crisis has been sorted because the Parliament has done its job. The National Assembly and the Senate have done their political job. What we are dealing with is constitutional and can only be given time. I would tell anybody who is saying, why are you delaying? No. Law operates in a procedural manner. If I bring a case now and somebody raises a preliminary objection, the preliminary objection ought to be dealt with first. In this case, application for recusal is a preliminary matter that has to be decided by the very bench that you want to rush to make this other decision that you want them to make in terms of lifting the conservatory orders. So I would say that in matters of law, matters of procedure, we should allow the procedure to play out so that we do not necessarily rush it. You can rush political issues, but please let's not rush judicial legal issues because the consequences, the damage is far-reaching.
So what typically happens when a judge recuses themselves or a bench, should they recuse themselves in this case? Beautiful.
Again, this is what we are saying, that there's no crisis. If they recuse themselves, then the Chief Justice is presented with an opportunity to again empanel another bench of judges. So, and there are enough judges around in the High Court, so there's no problem so far. And that's why it's not that these judges must hear this case. I would think that even they themselves, If they have no interest, if they have no reason to want to hang around, they themselves should say, look, now that you have raised this matter about our impartiality or lack of impartiality, it's likely that if whatever we render here may not be seen well. So they should actually be the first people to say, wait, we are accusing ourselves. The problem we are dealing with in this country, and perhaps many of the jurisdictions that we have, is that when you are talking about a judge recusing himself or herself, you are actually applying to the very judge, and that the judge can decide whether they can recuse themselves or not. Now, in normal circumstances, what would be the ideal is that the moment I raise an issue about your suitability, it should not be you listening. Somebody else should be listening and making that decision, because I should be making those arguments about you to that person, which could be that I'm actually making, I have evidence that you cannot conceal, and therefore somebody else ought to make that decision. For now, we have a very clumsy situation where I have issues against you, and yet I'm putting to you and asking you to recuse yourself. That is a bit untidy. What is tidier is if, for example, a judge were to come and say, I have an interest in this matter, I would like to recuse myself. Would you, on the other side, argue that, wait a minute, don't? Because no. It would be like, the moment the judge raises the issue, they would recuse themselves and would agree that we move on to the next level.
So in other jurisdictions, is that a matter that is arbitrated, so to speak, by another party?
And procedurally. So, and we see what the ideal issue is that increasingly there are rules of procedure that should allow that to happen. Is it really happening? And again, you saw the other day in the case of Justice Alito in the U.S. Supreme Court. The issue was raised, and the questions again came up. They say, look, how do you then listen to this issue when it's all about you? Again, back to the US, there is need to make sure that these rules actually grow so that judges can also distance themselves when they are accused, because they should not be deciding and trying a matter in which they are the accused. Mm-hmm. Yeah.
All right. So this is a highly politically charged matter. Will that, do you think, weigh into their decision?
I think so. In fact, the worry that I have is whether the judges and the judiciary at this point will act beyond reproach as to want to leave no doubt that they were impartial, they were objective, and whenever their impartiality was called into question, they acted appropriately. I would not entertain drama in a matter like this. These are not the only judges. And by the way, they are very smart judges. All of them. They are good judges. If you look at their history, they have made some very good decisions. I have nothing personal against them. My only issue is, here is a reputation about to be thrown, or some mud about to be thrown at you as a judge. If you have no interest in the matter, or if you have no opinion whatsoever, wouldn't it be your choice to say, wait a minute, now that you've raised this issue, I recuse myself. Can the Chief Justice empanel another one? Of course, it might happen that if at all what they are accusing them is right, it might happen that the next to be appointed may also have issues. Then you will begin to determine, is it really true, or is it just hair splitting? So that should be something else. So my view would be, it should not be something that we should be fighting about. It's like a moment you realize there could be a conflict of interest, the best thing is to do is to down your tools. They say, for example, in matters of jurisdiction, if a court realizes it does not have jurisdiction, it downs its tools, because whatever then it proceeds to do would be questionable. The moment my suitability or my objectivity is challenged, the first thing I should do is to say, wait, I leave it at that point. I don't agree, but I also don't want to give the impression that the decision I'm about to render is likely to be tainted. Mm-hmm. And that's what you want to do in terms of justice. All right. So that's why they say that you should be above Caesar's wife, reproach, above reproach.
All right, so I'll be the devil's advocate right after this, because I want us to catch up with Seth Olale. Seth Olale, what is the situation at the Milimani Law Courts at present? And perhaps you can also recap for us what transpired in the morning on the consolidation of cases.
Well, good afternoon, Olive. 3 minutes past Actually 4 minutes past 2:30 p.m. the scheduled time for the afternoon session, which will involve the hearing of a recusal application, or rather petition, by Gachagua's lawyers. This particular hearing expected to be presided over by the 3-judge bench led by Justice Eric Ogola, and what we are seeing right now is a very packed courthouse. Of course, this being certified as urgent, and that is why this particular court is presiding over this particular matter. You asked about a recap of what happened in the morning. There was a total of 4 matters that were being consolidated. It was basically a procedural mention for 4 cases that have also been empaneled to this particular 3-judge bench, like I said, led by Justice Eric Ogola. We also have Anthony Mrima and, of course, Lady Justice Frida Mugambi. So it was matters including Eddie Waiguru and Victor Ngatia versus the Senate and National Assembly. That was in the morning, and also another matter was that of Rigathi Gachagua versus Senate, National Assembly, and 2 others. The third mention was that of Dr. Clarence Eboso Mweresa versus the Speaker of the National Assembly, and the 4th matter that was consolidated in that particular mention was the matter involving Shiria Mtani na Shadrack Wamboi versus Speaker of the National Assembly and Clerk of the National Assembly, and 3 others. What we're waiting for is the hearing of the recusal application by lawyers representing Rigathi Gachagua, and of course we also have the respondents on this other side of the courtroom, involving the likes of the National Assembly, the Senate, Speaker of the National Assembly, Speaker of the Senate. We also have the Attorney General and, of course, the interested parties in this particular case, including the Law Society of Kenya. We are still waiting for the judges to make their way. They stated 2:30 p.m. We have also received communication by the clerk of this particular court inviting the council just to submit prior application when in terms of using the city system, that is the electronic application. Any matter that is pending, they have been invited to submit before the 3 judges make their way in this particular courtroom. Yesterday we saw also quite an exchange, of course, after that particular that particular ruling regarding the jurisdiction of the Deputy Chief Justice Philomena Mbete Mwilu, whether she acted in law while constituting the 3-judge bench, and of course the court here stating that indeed she was acting according to her rightful mandate and she did not violate any judicial rules. Now the next matter here is the second application from the Rigathi Gachagua, which is a recusal application. They basically want the judges here to excuse themselves or declare themselves unfit to preside over the impeachment proceedings against Rigathi Gachagua. That matter will be heard. We are yet to see the directions the court will give, how many minutes will be given to the petitioners, how many petitioners are going to unveil their case against the respondents, who include the Attorney General, the Senate, the National Assembly, and also remember that the President himself, His Excellency William Ruto, was also added as a 5th respondent in this case, and as well as Kithure Kindiki. On the other side, we had the likes of Law Society of Kenya being also included in this particular matter as an interested party. So all eyes live on the 3-judge bench, expected to make their way here anytime from now.
All right, thank you for that update, Seth Olale. Wakili.
Yes, please.
There was leave given yesterday to appeal the decision on, is it Article 164 of the Constitution with regard to the Chief Justice having the power to impanel a bench on issues of an odd number, on issues of substantially of law. So can the Court of Appeal hear that matter parallel while this matter is still live in court in the High Court?
Yes, it can. The only thing that I would argue is the expediency. What do you want to appeal against? It can be consolidated in an appeal when you eventually have reason to go to Court of Appeal. So going to Court of Appeal on an application when you have a substantive petition before the court isn't the best use of court's time. So I would argue that you can argue that on another day. You still have that opportunity. But for purposes of making this process move on, I wouldn't think that that's something that you want to pursue. So I would think that the teams that have been asked that were aggrieved are not likely to go the appeal route. Indeed, anytime you are not happy with any ruling or any decision, you are at liberty to appeal against it. The question being, what is the timing, what is the expediency, and so on. And of course, the Court of Appeal does not operate at a pace that you would want to imagine the other courts operate, because it has its own issues, it has its own timing. By the time you do that and you are pursuing this other one, the two matters may meet at the same point, depending on whether a decision has already been rendered or not. So I would not advise them to take that route.
Yesterday, there were a lot of allegations of playing to the public gallery. There was a tongue lashing that was given by the bench to the counsel of Rigathi Gachagua. Does that usually happen in cases where there's a lot of public interest? Do lawyers conduct themselves differently?
Whether lawyers conduct themselves badly or sometimes do not conduct themselves well, the court has no reason whatsoever to descend into that arena and also begin to tongue lash. And this was a habit that the Supreme Court brought up with using language such as hot air, wild goose chase. That is a language that is not invited in, this is an adversarial situation we are in this country. So the courts have to be the most patient and the most reserved party in this process, because what you say will go into either the other side of the conflict or will fan more disputes and so on. So I don't see any reason whatsoever for the bench to tongue lash parties, because it only opens an avenue for the parties to imagine that this bench or this court has taken position. So I would not agree with that position, and I would urge courts to be to guard their temperament, because people are looking to courts for arbitration, and that's the last place you want to be aggrieved from. Yeah.
But it's a fine line to walk, You want to, justice is not only done, it must be seen to be done, right? Yes. So you do want to appear not only but you also want to appear impartial and fair. On the other hand, you also don't want to be pushed around by the council, because you did hear Justice Eric Ogula, who is the presiding judge in this case, say they will not be taken around in circles.
Why? You're presiding over a matter. Why do you want to imagine you're being taken around in circles? You wait for your turn in the circle. If it doesn't reach you, then let them keep going round. So you don't have to say that you will not be taken round in circles as a court. Wait to declare your position on an issue. And you can say, we respectfully disagree, or we take this view, and you put it and you keep it at that. You would have said you disagree with them without saying you disagree, or without shouting, or without tongue lashing, or without inviting yourself to a dispute or to a quarrel. Because you see, if somebody is ready to howl at you and you're also howling back, what is the difference between the two of you? So I would keep on saying that for the courts, yes, they're human. Yes, they can be aggrieved, but they should be the last people to want to appear to be taking sides. You can disagree. You can, and you see, you have, the only thing is, this side has made their point, this side have made their point, you made a ruling and you sit there. If they don't agree with you, they have another recourse. You don't have to go in and tell this one. No. You render the opinion professionally so, and you leave the matter. Okay. Do not be part of the conflict.
All right. So the people who are asking how long will this process take, are you telling them to buckle in?
Buckle in. The wheels of justice, they turn slowly the turn in their own time. This is not like the presidential petition that have timelines. 7 days you file and 14 days you and even that has been said not to be an adequate time to prosecute any matter before the Supreme Court. We all agree, but that's what the Constitution is, so we are stuck with it. This one has no time limits. And anybody who is in a hurry, politically, you have already kicked the deputy president. So what other hurry do you have? The rest is now a legal process. If you could rush the parliamentary process, please, that was good enough because you are in control of the parliamentary process. But leave the legal process to take its course. Do not introduce rushy, hasty, and perhaps, again, biased approaches to court. So my view is, let the process play out. It will play out with time. Everybody understands the need for expediency and so on, and I'm sure the judges themselves will even give timelines, and let those timelines run out, like you can run their course. Like now you can see, they said come tomorrow, we will be here at this time. Of course, they say 2:30, they're not there, but again, maybe they're still somewhere processing other issues. And so you can't say, but you see, you said 2:30, how come you're here? You don't pick up issues like those. You keep on saying that if necessary, you can extend beyond 4:30 to 5 o'clock to 6 o'clock to 7 o'clock. If necessary, you can meet on a Saturday. If all parties agree, what is the problem? The issue is, let us then focus on justice and not on non-issues.
So are these the kinds of cases that are typically fast-tracked in the judiciary on account of public interest?
Oh, definitely. This is one of such. I mean, everybody understands, the judiciary understands, even the parties involved understand that we cannot keep at this game forever. Somehow we have to decide one way or the other. If Gachagua is out, whether Kindiki is in, that has to be determined sooner rather than later. And does that mean that Gachagua's rights are extinguished? No. He has a chance to go to the Court of Appeal. He has a chance to go to the Supreme Court. So we haven't had the last of this, and we are not likely to hear the last of it. Even if, for example, Gachagua was to win round one, in this High Court, the other party are free. The National Assembly are free to go to Court of Appeal. Maybe they can have it overturned, and then again we will have Gachagua back, or it is Kindiki in, and then Gachagua can go to Supreme Court. So these matters are here for a time. We started it. Let us just back up, hold back, and relax. I don't want to say bring out our popcorns. No, it's not as simple as that.
So we had Dr. John Hamino on the very first day, and he kept asking what you're asking. He's like, what is the rush? Allow lawyers to prosecute their cases. Does that have anything to do with the fact that this is the first time we have seen a deputy president impeached? And therefore, are we charting new territory?
And are we charting the new territories with the modicum and the decorum that the legal process requires? That's the point. We've seen a few abnormalities, even as now the judges arrive. I can see the judges arriving. We've seen abnormalities in the way the National Assembly prosecuted the issue. We've seen a sense of hurry, a sense of even the way the motion was couched and the way
All right,
it was
so
canvassed.
Wakili, as you pointed out, they have come in. So at this point, I would like to transition to the Milimani Law Courts. I've had in studio the head of public law, Daystar University, Dr. Martin Olo. Over to the court.
Thank you.
Authority to campaign to